right. Good evening and welcome. This is the March 30th, 2022 public hearing of the Land Use Commission. The City Code directs this body to hear applications for map and text amendments, special uses including plan developments, zoning relief, and appeals from decisions of the zoning administrator, as well as to make recommendations regarding the city's long-term planning goals and objectives. Depending on the type of matter, this commission will either make a final determination or send its recommendation on to City Council. Ms. Jones, would you please call the roll?
Right, Commissioner Arevalo.
Here.
Commissioner Halleck.
Here.
Commissioner Cullen.
Present.
Commissioner Westerberg. No, she's not here this evening. Commissioner Mordinchev.
Here.
Commissioner Johnson. I know I said he would not be here. Commissioner Linwall.
Here.
Commissioner Hugo also let me know he will not be in attendance. Commissioner Puctel.
Here.
And Chair Rogers.
Present. So with 7 members present, we do have a quorum. Also present tonight from city staff are neighborhood and land use planner Megan Jones, assistant city attorney. I'm assuming that's Mr. Brian George.
Yeah, I'm here.
Okay, just when it says the city attorney, I'm never sure exactly who's here with us. And zoning administrator Melissa Klotz. This is a formal hearing, and there are rules that govern our proceedings. Most importantly, only one person speaks at a time, so all testimony may be accurately recorded. Anyone who wishes to address the commission regarding any matter on tonight's agenda will have the opportunity to do so at the appropriate time. Commissioners may ask questions at any time. Our procedure is to hear from staff on the documents on file and then receive testimony and other evidence from the applicant or appellant. After that, persons wishing to make a statement regarding the matter will have a chance to do so. Any person with a legal interest in property located within the defined notification requirements of the subject property may present evidence, reasonably question witnesses, or seek a continuance of the hearing. When all supporting and opposing testimony and statements have been heard, the applicant or appellant will be given an opportunity for rebuttal or to make a closing statement. Then the commission will close the record and begin deliberations to consider the standards. The commission will make formal findings of fact based on the testimony and evidence presented, guided by the standards, the commissioner's knowledge of our community, and the recommendations of staff. All testimony is taken under oath. Although we do not apply the strict rules of evidence, please limit your testimony to the proposal as it relates to the standards contained in the zoning ordinance and the corresponding staff memorandum. When testifying, please state your name and address for the record. And since we're online still, if you want to be recognized when we get to the citizen comment section, if you would please just raise your hand and I will call on you as I see hands go up. Our meetings are audio and video recorded. Please make sure that your microphone and video is turned on when you are asking questions or making statements so that it can be properly recorded. I would ask also that if you are not actively engaged by making a statement or asking questions, to please mute yourself so we don't have background noise. All proceedings are subject to broadcast at a later date. Any matter not concluded at tonight's hearing will be continued until our next regularly scheduled meeting. Our agenda this evening, we have 3 issues. The first issue, which is under new business, for a public hearing for a map amendment, 22 PLND 0017. That has been withdrawn from this agenda. The staff will be renoticing that for a future date. So if you showed up to speak to us tonight on the map amendment regarding Central Street, Crawford, Grosse Pointe Road, we will not be hearing that this evening, but it will be renoticed to a later date. Mid-May, is that what I understood to be the approximate time for that?
Correct. It will likely be put back on the agenda in May. We are aiming to put it on an agenda where there will be another case in that same neighborhood so that hopefully neighbors have fewer meetings that they need to attend.
Okay, thank you. The other item that we have on the agenda that is 2356 Colfax Terrace. I see the applicant is here. And then the last item is just another business item for us to discuss our rules. So with that, I will ask at this point, anybody who may be speaking to us on any of the matters presented to us tonight to please take an oath. So if you would turn on your camera and your microphone, I will administer the oath, and then if everybody would just respond yes or aye after I issue it. So is everybody on? So if you plan on speaking to us tonight, do you swear or affirm to tell the truth throughout the course of these proceedings?
Yes. I do.
Thank you. And you can go ahead and mute yourself and turn off your cameras again if you'd like. The first item we have on our agenda this evening is the approval of our meeting minutes for March 9th, 2022. Has everyone had a chance to look through those, and are there any comments, edits that need to be made?
The only thing I saw was that at the very end, and it was that Commissioner Johnson seconded. I don't think he attended.
He was marked as absent, so I don't know. Maybe if you could look at the
I'll double
recording.
check.
I don't recall who made that second. If the person's here and remembers that they did. If not, if you would just look, Ms. Jones, at the recording and
I
double check
think it
that.
was me, Violetta Cullen, that made that second.
Okay,
No, you made the motion. Maybe Chris
Oh.
Westerberg, I think.
it may have been. We'll check the video to make sure we get the accurate recording of who actually seconded the motion. Any other issues with the minutes? Hearing none, is there a motion to accept our minutes?
I move to accept.
I'm
Moved by-
second.
Moved by Commissioner Halleck, believe a second by Commissioner Cullen. Any further discussion? Hearing none. Ms. Jones, would you please call the roll?
Excuse me. Commissioner Arabalo,
Yes.
Commissioner Halleck,
Yes.
Commissioner Cullen,
Yes.
Commissioner Merdenchev,
Yes.
Commissioner Linwall,
Yes,
Commissioner Pucktell,
Yes.
Chair Rogers.
Yes. With that, I think everybody voted, so that'd be a 7-0 vote.
Yes.
The motion or the minutes are approved. With that one change on who made the second. Again, we are not hearing the map amendment. If someone joined us late this evening, that will be renoticed to a later time. And so we will move on to our next item of new business, which is 2356 Colfax Terrace, 22 ZMJV 0018. Is Ms. Klotz reading this one into the record? If you would do so, please. Thank you.
Thank you, Chair Rogers. Sarah and Patrick Hillman, property owners, submit for major zoning relief in the Evanston zoning ordinance for additions to a single-family residence in the R1 single-family residential district. The applicant requests zoning relief for 46.1% impervious surface coverage where a maximum 45% is allowed, section 68210, a 27.5 east front yard setback where 38 feet is required to meet the block average, section 6419, a 1.5 foot north interior side yard setback where 5 feet is required, section 6828, a 15.6 foot west rear yard setback where 30 feet is required, section 6828, a detached accessory structure, chimney or fire pit, in the front yard where detached accessory structures are only permitted inside and rear yards, sections 6462D and 6463A, a 6 foot and 7.3 foot solid fence in the front yard where fencing is not permitted within the front yard or within 3 feet of the front facade of the house and not over 4 feet in height or 70% opacity. Section 6467. The Land Use Commission is the final determining body for this case per section 6389 of the Evanston zoning ordinance and ordinance 92021. Revisions were submitted on March 9th, 2022 that eliminate variations and bring the new request to a total of 3 variations. The 3 variations now requested are a 1.5-foot north interior side yard setback where 5 feet is required, an 11.7-foot west rear yard setback where 30 feet is required, and a fence in the front yard where fencing is not permitted within the front yard or within 3 feet of the front facade of the house, 6 feet in height where 4 feet is allowed when in a front yard, and solid where a maximum opacity of 70% is allowed when in a front yard.
Thank you. So just a clarification, we're down to 3 variations now, which is the north interior side yard setback. Did I mark these correctly? I want to make sure I marked the correct ones.
Correct.
The west rear yard setback
Correct.
and the front yard fence height and opacity.
Yes, specifically the fence that is along the alley, not the previous wall that is no longer considered a fence because it is now attached to the house.
Right. So this is we're talking about the fence that runs basically from the bike room, roughly that portion of it from the bike room to the middle of the cul-de-sac property line.
Correct.
Okay, I just want to make sure I have the right ones here marked. For people following along, this is on page 66 since we skipped ahead here in our packet. So Mr. Hillman, welcome back. And if you would please tell us about the changes in your proposal.
Yeah, well, I think, I'm gonna keep this short because I think we heard you folks pretty loud and clear last time. There was just, there was too many variations that we had requested. And so, we worked really closely with Melissa and the entire staff to get it down to just the 3, which were critical for us to move forward the project, so that we can really 3 things. Number 1, we want to be able to build a house that will house a growing family of 4. We want to be able to maintain the look and feel of the neighborhood, the light and airiness, and not encroach on our neighbors any more than we would like to or they would like us to. We want to protect the trees. We brought in an expert to help us and help Joe decide how to help build a house so we can keep all of the trees that are on the property. And most importantly, we want to add to the neighborhood in a way that's both beneficial to a property that has been vacant for almost 20 years. Again, allow for that green space, block out some of that alley light, and have a safe space for children to be able to go and play and not have access directly to an alley. I want to thank Melissa and her team. Like, they worked really close with us and compromised with us and helped us find, I think, the right path forward. And so we're pretty happy with kind of where this landed. I think most of the changes were really just, again, moving slightly closer to our alley line, although again, still we've had that fence there for the last 50 years and we're not building up on that fence line. That fence line has been there forever and will continue to be the standard fence line. But yeah, I think that's it. I know we've had a number of our neighbors reach out kind of on our last call. It was kind of raised as we didn't really have a good check on where the neighbors were on this. So a number of our neighbors were nice enough without us even asking to reach out to various folks to raise their support for this project. And we're hoping that with the positive review now from the staff that we'll also get a positive outcome here so that we can start building and not have to abandon the project.
All right, thank you, Mr. Hillman, I'm sorry. Hinman's the street we have in town. So with that, are there any questions from commissioners for the applicant at this moment? I don't see any. So I will now open the floor up to anyone who wishes to speak to us on this issue. I know there were a couple people who had. Before I do that, though, I do want to respond. One of the neighbors, Mr. Hillman, had written to staff and asked them to forward that on to me about our last meeting. And I just want to make something clear and put it kind of on the public record. I don't respond to those, and it's not because I don't want to respond to those, but because of the fact that I'm a deciding member of this body. I don't like to negotiate things and discuss how other commissioners voted and why they voted that way or anything else with anyone else. So that's the whole reason I will not respond to those, and just putting that out there. So it's not I'm ignoring people. It's just it's not appropriate for me to respond.
Just
I don't know if that person's on the line tonight, but I wanted to put that out there. So you don't have to respond to me. I just wanted to make that statement that it would be inappropriate for me to respond directly to people about the actions of this commission. So with that now, I will go to anyone, if you would just raise your hand if you want to speak to us on the matter. And I see you, sir, but I don't know what your name is, so you can go ahead and unmute yourself and give us your name and address, please. You're still muted.
Now,
There you
okay.
go.
Yeah, my name is Bob Stevens, Robert Stevens. I live I'm the property owner at 2346 Colfax Terrace. And my property is most immediately adjacent of any property other than the alley to this property under discussion. My wife and I have lived with the fact that this residence, as it exists now, has been vacant for over 20 years and is in a state of marginal disrepair and abandonment. And we are really excited about the Hillman's proposal. We are excited on several levels. One is we feel like it's appropriate for the space, whereas there could be the possibility of horrendous McMansion type expressions there. And that's not what this is. And we're thrilled. So the appearance, the location of the property, the fact that it's not encroaching, inappropriately on our space, and the just the care with which the Hillmans have taken to make it usable, to make it appropriate for the cul-de-sac, have just been terrific. The second thing that appeals to me is just the people themselves. They are good. They're going to be good neighbors. We have gotten to know them solely through this process and have found them to be just winsome and the kind of people that Evanston wants and needs. And I would hope that we could embrace some amendment and some regulations that really don't quite apply to this site, but are being applied here, and look at the thing through those lenses. So I just want to put in my word. These are good folks. Let's do right by them.
All right, thank you. I see the Goldmans have turned on their camera, so I'll let them go ahead and speak next.
Yeah, I'm Bob Goldman, my wife Ann Ryan. We're at 2353 Colfax Terrace, which is just across the cul-de-sac from the property under discussion now. And I think Ann wanted to say something.
Right. Unlike Bob, we've never met the Hillmans. However, their cause is near and dear to us. We measure the time that house has been vacant by the age of our daughter, who will be graduating from college in about 6 weeks. So it has been vacant for 20 years and quite the eyesore. In fact, this past spring of 2021, I believe the city fined the owners at that time because the fence was falling apart. So it has been a neighborhood eyesore and completely dilapidated. I'm surprised that, you know, kids haven't broken into the house or something has happened to it because of the dilapidated nature. So we have been thrilled that the Hillmans have been interested in joining the cul-de-sac. We're a very tight-knit little group on this cul-de-sac, and we welcome them with open arms and are so pleased that they're willing to undertake the rehab of this dilapidated house. So we fully support and welcome them and look forward to their children growing up in the cul-de-sac. We're the neighborhood bike riding learning circle for every kid in the neighborhood. They come over and ride in the cul-de-sac because we have so little traffic. So we really welcome the Hillmans and hope that this will go through this evening.
Thank you. Was there anyone else who wished to speak to us? I don't think there's that many other people on the line. I think we lost a bunch of people when the first item came off the agenda, but I don't see any other hands going up. So Mr. Hillman, I will ask you if you have anything you'd like to say in summation before we begin our deliberation.
No, I think we just like to thank everyone for their time and particularly for our neighbors, those we know and those we just met on this call for phoning in and providing that support. We really appreciate it. And thank you, Melissa, to you as well for all of your support over the last couple of weeks too. Thank you.
All right, thank you, Mr. Hillman. Seeing nobody else who wants to speak on the matter, I will go ahead and close the record so that we can begin our deliberations and ask commissioners if there's anybody who would like to start us off on the discussion. And if not, I will start us off, or Commissioner Lindwall.
I'll start.
Oh,
I'll-
let George start.
Okay.
Yeah.
Have a really minor comment.
As you know, I voted for the last scheme, and I'm happy about a couple of things. One is that Mr. Hillman did not sell the property and has come back to us with a I consider a slightly revised scheme, although the numbers of the variations have come down quite a bit. So the second thing is that I always thought that the concept for the site was, and it's a very unique site, and I kind of agree that all the zoning regulations really don't apply to this site in the same way they do to typical sites in Evanston. So I'm very glad. I thought the concept was very thoughtful, and I'm glad they stayed with it. And that's it.
Thank you, Commissioner Halleck. Commissioner Lindwall.
Okay, and I appreciate the number of variations has been greatly, reduced. And I think my one comment is that just in terms of maintenance and dealing with leaves that are gonna fall, from the.
Just a minute. Commissioner Collins, thank you. Okay, go ahead. I was getting some feedback there.
Yeah, I just think that you ought to think about rather than a 1.5 north interior side yard, you might want to consider going to 2 or 2.5 feet if you can, just because I think it may make maintenance easier in the long run. Although that's I'm okay with the 1.5 setback, the basic request, but I think that that's just something you ought to think about, how you're going to rake the leaves for your 1.5 foot setback and along the alley. It's just, but that's my only real comment. I think that the front and rear yard, or I guess it's the fence and the rear yard setbacks are certainly appropriate.
Commissioner Miranchev.
Thank you, Mr. Chair. So I will join my colleagues. I like the project, and I would say it's a really good project and a kind of a innovative project. And my vote will be yes for this project, definitely. The one note that I will afford, and it is just architecturally, if you consider reducing I will call it the weight of the fences in a manner that they're much more appropriate, either with vines, with something else. I'm afraid that the inappropriate material, for instance, will make them look too heavy. And I actually really like the inventive thinking of making the fireplace part of the house. It's a good trick that I really like. But once again, I would advise to be considerate about the weight visually of these things that are out of the house. So these are my comments. Thank you.
Thank you, Commissioner. Any other commissioner have anything they'd like to add? If not, I will just go. I appreciate the reduction in the number of variances. I think it's very important that we try to keep projects as close to the zoning ordinance as we can. The one problem I do still have with this is the 1.5 north interior side yard setback. Because of the fact that I think that could be easily accommodated by shifting that portion of the house south. And so that's the one that I just really struggle with here. I have no problem with the rear yard. I think the fence in the front yard, as long as we're talking along the alley there, is highly appropriate and is very important, especially on this type of a property where you look into an alley. So as people come to the front of their homes on the cul-de-sac, they aren't looking at trash cans in the back of garages and everything like that. So I don't have a problem with those two variations. I still have a problem with the 1.5, but I think I'm kind of in the minority on that. I guess we will go ahead and go through our standards.
Can I ask a question and,
Sure.
and sort of make a comment on your comment, Commissioner?
Yep.
Clarification, the north yard setback, the 1.5 is along the alley.
Yes, it is.
And typically we don't have in Evanston large setbacks along the alley. My fence is right on my alley property line. It just so happens that this is such a unique situation here that it falls under a different category. But I think we need to recognize that it is the alley. The reality, it is the alley.
It is the alley, and our alleys do require a 3-foot setback on garages. Fences are different, but any structure we require a 3-foot setback on. And this is a side yard, not a rear yard. It's a uniqueness to this property. And I don't think we're going to convince each other here. I think I've made my point and you've kind of made your point, and I think we disagree on it.
Let me just add one more thing. The 3-foot setback is, I believe, is to allow a turning into a garage.
Yes.
They don't have that situation here.
And if a garage were not present, it would be a required 5-foot setback as it is, because this is not the rear yard. This is a side yard.
Okay.
And so I'm not going to belabor it with you because I think the votes are there for them to get what they want. Just in general comments. So rather than keeping us here late with you and I discussing philosophies, I think we'll go ahead and move through the standards. And as I mentioned, I support the other two. It's that one in particular that I have a problem with. So in order to make a determination of any property variations, we must find that 7 standards are met. And if we feel that they can be met through applying conditions on properties, we are able to do that as well, but we must approve these in order for a yes vote to move forward. So I will go through those. The first one being the requested variation will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. I believe that this standard has met. We've heard discussion about how this is a property that has sat vacant for somewhere in the neighborhood of 20 years. And driving by and looking at the property, obviously there's not been much done to it. It exists only because it was built well at the time it was built, but it's not been maintained for some period of time. So obviously improving this property will bring property values up in this neighborhood. So I believe that standard is met. Number 2, the requested variation is in keeping with the intent of the zoning ordinance. This one is obviously we want people to try to redevelop decrepit, and I'll use that term, I guess it's not necessarily appropriate for this particular building though, that has been somewhat run down and empty for the past 20 years. We seek to have those redeveloped where we can. So I believe that standard is also met. Number 3, the alleged hardship or practical difficulty is peculiar to the property. This is one where I think on the 2 that I believe should be met, which are the rear yard and the fence along the front yard. I believe those are both met. I have a problem with this one for the 1.5 north yard setback. But I think that I'm in the minority there, probably the only one maybe even who feels that way. So I don't believe it has met, but I believe that a number of my other commissioners believe that it has been. The property, number 4, the property owner would suffer a particular hardship or practical difficulty as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. I'll kind of reiterate my finding on 3. I don't think that the movement of the north property or the north wall to at least 3 feet or possibly even the 5 feet, I think that's not going to put the project in jeopardy or drastically change things to a point that it creates a hardship for them. But I believe that, again, I'm in the minority there, and that most of the other commissioners believe that that is not the case. Commissioner Lindwall did mention, consider if this is your plan, how you rake leaves from the trees, things like that. If you've got a very small space in between the wall and a fence along there. Number 5, the purpose of the variation is not based exclusively upon a desire to extract additional income from the property. This particular property, the homeowner intends to build and live in. They are not building anything that would generate an income for them. So I believe that standard has been met. Number 6, the alleged difficulty or hardship has not been created by any person having an interest in the property. This one, again, we've heard lots of discussion about how it's a somewhat weird property because you have a slant along the rear yard, which is poplar, and you have the cul-de-sac, and the property, actually the front yard property line begins in the middle of the cul-de-sac. So it is a unique property, and those conditions have not been created by Mr. Hillman. So I believe that standard is met. And number 7, the requested variation requires the least deviation from the applicable regulation among the feasible options identified before this body. Again, I will say, I think on the 2 variations that have been requested regarding the rear yard and the fencing across the front yard to screen the alley, I have no problem with those. I still have a problem with the 1.5 side yard setback on the north side of the property along the alley. Does anybody want to add anything to my findings on those standards? Commissioner Miranchov.
I just want to be clear. There is no fence at the 1.5 feet.
Right.
It is just a setback, no fence over there. So, and I believe that's correct.
Okay.
I see the architect.
Yes, I see him nodding his head.
So there is no fence over there, and I think that there will be no problem with leaves or serving this part of the yard. That's why I think that it's okay with me.
Okay, thank you for the clarification. Any other comments on the standards? Seeing no one, I will ask Ms. Jones if she would please call the roll. Or I'm sorry, I need a motion first on 22 ZMJV 0018 for Colfax Terrace.
There also are conditions that Dapper recommended.
I was going to get to those after we had the motion, and then we'll
Okay.
decide which of those we want to add in.
Okay. I will move approval.
I'll second.
Well, wait a second, let's get the motion in with the-
Properly. I will move approval of the requested variations for 2356 Colfax Terrace, 22 ZMJV-0018.
Okay. And there's a second from Commissioner Halleck.
Mhm.
All right, let's talk about the conditions that were discussed at Dapper. I'm going to bring those up. So there were a couple of conditions, and I don't know, Ms. Klotz, if you want to chime in here. I know this has kind of been a moving target somewhat. So I don't know if Dapper looked at the exact same plan we're looking at.
Yes, Dapper did review the most recent
Okay,
update.
I just wanted to make sure we weren't going to talk about something different than what they saw. Okay, so it appears that Dapper had two conditions that they wanted to discuss, which was that the bike room location be revised to attempt compliance. So Ms. Klotz, do you want to talk about what exactly the concern was there?
Sure. There was discussion about whether the bike room could be shifted to the south to comply. And my understanding is that it's tricky because of tree locations, and how to not impact routes the most. And it was left as, if there is a way to shift the bike room without further impacting any trees and also not extending into the front yard setback, that would be a good thing, but that was if it's possible. So that's why the condition was stated the way that it was.
Okay. We'll just have a quick little discussion on this. It doesn't appear that any of the commissioners really have a problem with the placement of the bike room, except for me. So I don't think that's a condition that necessarily we are in favor of putting in place. Is that the general, just shaking your heads? Yes.
Yeah, I think that's.
Okay. And the second one was the fence segment along the alley between the attached garage and Poplar Avenue be no taller than 42 inches. Now they would be required for the site triangle to come into play here. Is that correct? The last 8 feet?
The way the zoning site triangle works, it extends from, if the curb truly came to a point and it's measured out from there. So the zoning site triangle is not the best safety wise. So that condition was requested by Public Works to ensure better visibility.
So we're creating kind of our own sight line triangle without it being there.
Correct. And the applicant did state at Dapper that they had no problem with that.
So I saw him shake his head during that, and he just gave us a thumbs up there. So I believe that's a condition that we could apply here, and it makes sense. In order, the applicant has no issue with it, and it does make sense for safety, to make sure that anybody coming down the alley does not hit anybody coming up Poplar Avenue, although Poplar is a dead end there, but we don't want any accidents to occur, particularly with pedestrians. So that would be a condition I think that we should put into place. So if there's a motion to add that into the original motion, we'll take a vote on that then first. So if somebody wants to make a motion that the fence segment between the alley and the alley, attached garage, and Poplar Avenue be no taller than 42 inches.
So moved.
Moved by Puctel. Is there a second?
Second.
Second by Lindwall. All in favor of that condition. Ms. Jones, if you would please call the roll.
Commissioner Arabella,
Yes.
Commissioner Halleck,
Yes.
Commissioner Cullen,
Have we lost her? We may have lost her.
okay, we'll come back. Commissioner Marinchev,
Yes.
Commissioner Linwall,
Yes.
Commissioner Puctel,
Yes.
Chair Rogers.
Yes, so that's a 6-0 vote, since we've lost Commissioner Cullen. So that will be part of the original motion. So now, any other changes that anybody would like to make before we vote on the original? And I'm going to wait for just a moment to make sure Commissioner Cullen, can you maybe reach out to her and see if she's trying to get back? And the only reason I'm doing this is because we need 6 concurring votes. And with only 7 members and me voting no, I don't want to hold up your project for 2 weeks. So if we can try to get her back on to cast that vote for us. So what I'm going to do is I will ask Ms. Jones to call the roll. We'll take the vote. I will not close and announce the results of the vote so that if Commissioner Cullen joins us back, we can wait for that to close out the vote.
Okay. So let me pull up the list. All right, Commissioner Arabalo,
You're muted.
Yes.
Commissioner Halleck,
Yes.
Commissioner Miranchev,
Yes.
Commissioner Linwall,
Yes.
Commissioner Patel,
Yes.
Commissioner Cullen.
Commissioner Cullen is back.
I'm back. Yes, I got knocked off. Yes.
All right. And Chair Rogers.
My vote is no. So with a vote of 6-1, the motion does carry. So the project is approved with those 3 variations that were requested. So Mr. Hillman, if you reach out to staff, they will let you know how to move through the next steps of beginning your project, and good luck with your project. Thank you.
Thank you, everybody.
With that, we will move on to other business. We have revisions to our Land Use Commission rules and procedures. And my understanding, this is the discussion about the concurring votes and how we're handling that while we're in a transition period, and trying to word it so that it makes sense. Ms. Klotz, are you taking us through this one as well? I mean, do you want to just touch on it, or?
Sure. So it's a revision just to one paragraph of the rules. The way the rules were written, they were intended to be the final rules when we have our final membership of 9. Unfortunately, that meant that it was a little unclear in a previous case, and our law department asked us to clarify that even during this transitional membership, what is the vote? How does it work? So for final determinations, we have made it a little wordier, but to be extremely clear that a final determination must have the majority of the seats on the commission, whether there are appointed members to those seats or not, rather than just stating what number that is, since our membership is evolving over time a little bit.
Thank you. I have a quick question for our city attorney on this.
Yes.
Is there a way that this could be put into the section on our transitional? So when we move to a final board of 9 people, which we're getting very close to, we've already lost 1 member, so we're down to 10. Is there a way that that could be put in there so that when we do our final set of rules, we literally just strike out the paragraph on the transitional board and we have a number? Because I think the wordiness of this, where it's accurate, gets very confusing to people who don't understand our rules.
No, law does, it's law's opinion that having a number, just like an actual specific number, is not a good idea, just because, you know, this situation was pretty unique, but just on the off chance that it would happen again, I think it is pretty wordy just to clarify that it is the total number of commission seats and not the number of seated commissioners. But, you know, we just wanted to err on the side of making it absolutely clear, even though it is probably more verbose than, you know, is ideal.
Okay.
But it is law's opinion that having an actual number there is not, you know, it isn't a good idea.
All right, I will defer to law on that, although I think this makes it slightly more confusing for somebody outside who's reading our rules because of the verbosity of the, I don't know if that's a word even, verboseness of the way it's put, as opposed to just being able to give a number since we are a unique body with our determining power and having to have a certain number of votes. But law's the one who, if we ever go into court, is going to have to defend this. I don't have to. So I was just looking at a way to try to make it more clear for people, citizens who read our rules, to understand fully what we're talking about here. So I'm fine with that, the way that's worded. The thing that I do want to mention right now is that because of this rule, it's vitally important that commissioners try to make meetings, because of the fact that with the determination aspect of this, as you saw tonight, if we lost one person and only had 6 people and we have 5 people vote yes and 1 person vote no, that continues it for another 2 weeks. So I'm not talking to anybody necessarily in this room because you're all here, but that we should try to make efforts to do this because of the fact that missing a meeting can delay somebody's project by 2 weeks on that.
Can I add something to that? When I joined the commission several years ago, I thought there was a policy that said that if you miss 2 meetings, maybe in a year, I don't remember exactly, but I know there was something that tried to, say that, hey, you got to be there. And if you're not there, if you don't attend, you're not part of the commission. And I don't know if that still exists or whether that it should exist as part of our.
Yes, so in our rules, we do have, and I'm trying to find the exact section so I can give you the exact wording. We have placed something in our rules so that, Melissa, do you know exactly where that is?
I don't remember offhand. We ended up with a combination of what the zoning board's old policy was and what the planning commission's policy was. I don't remember exactly what it is.
I think it's, but anyway, it's if you miss a certain number of meetings out of so many meetings, the chair goes to the mayor, because the mayor is the one who ultimately has the authority to remove members or to discuss with members their commitment to this board, and so that we can actually do our business. Because when I first joined ZBA, we waited for 2 months for the 7th member to show up because we had a 3-3 vote. And that project was stalled for 2 months until that person could vote. They came, they voted and resigned all in one meeting, but we needed to have them do that in order for it to happen. So, we do take attendance. I take note of the attendance. I'm meeting with the mayor on Monday just to sort of introduce myself to him and kind of introduce him to Land Use Commission now that we've kind of become this different body. And so that's one of the things I will be discussing with him, is that from time to time, I may be coming to him, asking him to speak with people to either reinforce their commitment or ask them to move on so that we can have a board that actually functions. Again, it's not as important with the recommendations, but it's very important with the determinations that we have the number of votes that need to move it forward.
And I think it's something that all of us should be reminded of too, because it's very easy to, let's just say, look at the agenda and say, I'm not interested in those subjects, so I don't attend, and still be a part of the commission, which I think is wrong. And so I think everybody needs to be reminded of this policy.
Right. I mean, they miss you and I discussing side yard setback theories. Who wants to miss that? Commissioner Miranchev, you have your hand up.
Yes, I have a kind of a question that probably will speak that I did not read all the things, but in the case that we move back to in-person meetings, will it be allowed that some of us are joining remotely or not?
My understanding, and I'll let Ms. Klotz discuss this, but my understanding is the city discourages that because of the staff that they require. They require to have technical staff on hand to coordinate the people in the room with the people that are digitally there. For example, Ms. Jones right now, I believe, is running our Zoom meeting. But when we're in an in-person meeting with lots of other activity going on, it's difficult for her to do that. So we have somebody who comes in order to do that specifically. So city staff is not really equipped to handle the hybrid meetings, so they discourage those. Any other questions? I mean, we've gotten a little off the main topic here, but it all kind of tied together with this.
I have a question. Is it clear what's meant by seats? Is that clear to everybody?
I mean, to me, that's clear. It's what you refer to, we hold a seat. I mean, it could be positions, I guess, or.
The website talks about members of the commission.
I think the addition of the language that referring to the seats, whether they're appointed or vacant, is meant to clarify that it is the number of seats that are, you know, on the commission as a whole, not the ones that are currently occupied.
So when you say members, you think of the people who are physically in a seat, but we also have to count the empty seats. So if we had 4 people and there were 3 empty seats, and this is just an exaggeration, we would never be able to do any business. Because I guess it would be 4 and 5.
Right.
So that's
Also,
why it's
any-
important, because it's different for us than it is for a lot of other boards.
Also, where, you know, you can tinker with the language a lot, but it would, you know, there still might be some ambiguity there. I think the fact that we're having this discussion and staff knows what it means, we would be able to clarify that yes, it indeed is meant to be the number of commission seats and not the number of seated commissioners at that current moment.
Right.
Okay. Yeah, I see how that's adding some clarification. And I guess I just do have one question, which is slightly off the topic, but can the attorney maybe comment on maybe why the approach is to have concurrent votes of a majority of seats rather than making sure there's a quorum, one, and then having a majority of the quorum?
Well, there always has to be a quorum for any business to, you know, proceed. But in terms of the voting, this is just consistent with what it was written into the rules previously with that number 5. It was written as 5 votes is needed, and you know, when it was contemplating a 9-person board, and you know, like, it didn't make any sort of what should I say, if the number of commissioners, there was a vacancy or 2, if it was 8, or if it was 2 vacancies and it was 7, the number 5 was still there. So it was just to remain consistent with that. Whether, you know, whether it's going to be a majority of a quorum or not is, you know, it could be, but we just, you know, state laws would suggest that it should be a majority of the number of board seats. But since we're I'm getting kind of in the weeds here, but since we're in a home rule municipality, we can diverge from state law, but we're just doing that to remain consistent with what it was before.
I see.
Just to add on to that, yes, when the zoning board of appeals was the determining body, it had 7 members, and the ILCS state code that applies to non-home rule communities specifically says that for final determinations, a zoning board must have 7 members, and a final determination must have at least 4 votes, regardless of how many members are appointed at that time. Now that does not apply to Evanston because we are home rule, but following that best practice, we want to apply the same thing. We don't ever want a final determination to be made just based on the randomness of what commissioners happen to attend a meeting. So this way we get more consistent final determinations.
I hear you. I guess I'm getting a vibe that the concurrent the majority of concurrent majority of seats is presenting a bit of a burden on this group to be able to move things along. Just in the last few meetings, things have been moved. I mean, we just started this in 2022, and we've already had numerous examples in our meetings of cases being continued and making sure we're like looking for one vote. And I guess I'm just expressing concern that I think this burden might be difficult.
And I think that goes back to the commitment of the commissioners on the board, that we need to have people who are committed to being here because of the fact of that. The downside of that is, like Ms. Klotz said, I mean, if we have a majority, our quorum when we get to 9 is 5. So you can get something approved with 3 votes, but somebody else comes along and needs to get 5 votes because of who shows up at a meeting at any particular time. And it kind of throws a wrench into the consistency of our rulings. And whereas, we don't work off precedent or things like that, because all properties are slightly different, all projects are slightly different, it does create a situation where if you get the right mix of 5 people, which is the bare minimum for the quorum to occur, you can get things through that you wouldn't get with a full board. Which leads me to a question, since we're kind of discussing this with the city attorney. Currently, we're a board of 10. So what is our number? I mean, our number is 6 still, but what happens if we end up with a 5-5 tie at some point in the future? The motion fails.
Correct.
So that's a situation again where it's nice to know who is coming and everything else. Right now, I'm happy when one person is gone because we don't end up with a 5-5 tie on things. But that's something also to consider as well. I think we've kind of talked about this. I don't know if anybody has anything else they want to add. If not, I'll just ask if there's a motion to adopt the rules with the changes that have been proposed by law and staff.
Make a motion to adopt the rules with the proposals that have been proposed by law and staff.
Thank you. Commissioner Cullen moves. Is there a second?
I'll second.
Second from Lindwall. Ms. Jones, would you, or any further discussion? Hearing none, Ms. Jones, would you call the roll, please?
Commissioner Aravallo,
No.
Commissioner Hallett,
Yes.
Commissioner Cullen,
Yes.
Commissioner Miranchev,
Yes.
Commissioner Linwall,
Yes.
Commissioner Patel,
Yes.
and Chair Rogers.
Yes. So with a vote of 7-0, the motion carries and the new rules are adopted. Just a real quick note, I found the rule that we were talking about earlier. So if a commissioner has failed to attend 4 consecutive meetings is when we speak to the mayor about removal from the commission. If somebody misses 4 months worth of meetings, they're automatically removed. I can't see us ever having somebody on the board for 4 months without them attending anything or not having an excused absence or something like that. So
Matt, I do have a question. So in my case, I'm planning to go in for surgery.
Right.
And to be able to attend a meeting in person, I may be out for 6 weeks. That means I would be missing at least 3 or 4 meetings.
So I would prefer that we talk about this offline instead of in a public meeting, because this is a recorded public meeting and I don't want you to have to disclose anything or have any discussions. But I'm aware of your situation through Ms. Klotz. And so I think that's something maybe that you and I just talk about offline as opposed to here in a public meeting.
Okay.
if that works for you. I mean, I don't want you to have to go into anything or potentially get us into a discussion where things get kind of weird and awkward for us. So I'd rather us just talk one-on-one. I will now say if there is, the next item on the agenda is any public comment. If there's anybody here from the public who wishes to address us on any land use issues, I see we still have a few members of the public with us. If you just raise your hand or let me know. And I don't see any hands going up. So with that, unless there's any other issues to be brought before this board, I will ask if there's a motion to adjourn.
Motion to adjourn.
Commissioner Linville moves to adjourn. Second from Commissioner Puctel. All those in favor, this is not a roll call vote, please say aye.
Aye.
With that, we stand adjourned, and our next meeting will be on April 13.
Yes.
So April 13th will be our next regularly scheduled meeting.
Is that in person? Is that in person?
That is scheduled to be in person at this time, unless something weird happens with the governor making a different proclamation. But I don't even, we wouldn't even know that because this proclamation runs through the 2nd. So we would have to notice this meeting as being an in-person meeting, and we would have to meet in person to conduct any business.
It is
So the
in
next
meeting
one-
in person, no matter what.
Right, the next one is in person, no matter what.
Right.
All right. And I will see everybody then. Thank you very much for showing up tonight and making this a quick meeting.
Good night, Matt.
Good night.